You, Ruben Alejandro Alonso Herrera.
Yes, Judge.
So you're charged with failure to comply with duty, striking an unattended vehicle. You're facing up to 6 months in jail and or a $2,000 fine. You're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir.
Yes, Judge.
Okay.
The officer was dispatched to a residence in Harris County, Texas, in response to a failure to stop and give information. The complainant reported that his brother was standing outside when he heard a loud bang and saw a silver car striking the complainant's car, which had been parked in the street. The complainant and his brother immediately began pursuing the vehicle and observed it parked in front of a residence down the street. The complainant took photos of the defendant exiting the vehicle and going into the residence. When officers asked whether the defendant remembered striking the complainant's vehicle, the defendant stated, "I probably scraped by it, but nothing at all. It was dark out."
What's the value?
Let's see, Your Honor. Approximately $1,500.
Judge, I don't think a rip has been done, so there's no estimate. We don't know who.
Yeah, I get it, but at least it needs to be over $200. That's why. Mr. Alonso Herrera, I'm going to find that there's probable cause to go forward with your case. Do you have a valid Texas driver license, sir?
Yes, sir.
You have valid liability insurance in your name.
No, Judge.
Then you're not allowed to drive. And I'm making that a condition of your bond until you have liability insurance and show us that you have liability insurance. I'm making it a condition of your bond that you're not to drive. I don't care where you're going. I don't care what you're doing. Do you understand?
Yes, Judge.
You will be signing an affidavit with me today promising me that you're not going to drive. If I find that you do, it's possible that I have a contempt hearing. And every time they prove to me that you're driving a vehicle, you can be facing up to 6 months in jail and or a $500 fine. Do you understand?
Yes, Judge.
Now, you have a lawyer. Good job on having a lawyer. Because you have one, I will waive your appearance, but it's your responsibility to stay in touch with Mr. Adroga, and he will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest.
Yes, sir.
Pick up a new case, violate any conditions. Likewise, you will go to jail. You will not get any more PR bonds, sir. All right, I will have you come up here, swear to us that you're not going to drive. I'll get you the Victoria sign and reset, and then you guys are good to go.
Thank you, Judge. May I be excused?
Yes, sir. Thank you.
All right, Judge, page 1.
You, Miss Alasia Williams? Miss Williams, I'm sorry? Ma'am, you're charged with possession of marijuana. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, ma'am.
Yes, Judge.
Okay.
On November 14th, 2024, the officer observed the driver of a vehicle not wearing his seatbelt, and the traffic stop was initiated. The motor vehicle was occupied by a front right passenger, the defendant. The officer observed a strong odor of marijuana emitting from the vehicle, and the driver stated there were no drugs or weapons in the motor vehicle. Prior to the motor vehicle search, the defendant stated she had a weapon inside the motor vehicle, and a search was conducted where the officer found a purse on the passenger seat containing a 9mm handgun and a bag containing a green leafy substance identified as marijuana based on training experience. The weight of the marijuana was 3.1 grams.
So there was a smell of,
There was an odor, yes, Your Honor.
so what happened with the driver?
I don't see a connected case for the driver, Your Honor.
Ma'am, I'm going to find that there's probable cause to go forward with your case. How old are you, ma'am? What do you do for a living? I didn't hear you. What did she
Instead
say?
of DJ, Your
Oh,
Honor.
you're a DJ. Okay. And where do you work?
I just like bookings, parties, events, weddings, family reunions.
Okay. No more marijuana, ma'am. As long as you can abide, then we'll be fine. How much money do you make a month, ma'am?
800
On average, what do you say? What do you think?
I call them in a week.
A month, on average. Are you able to afford a lawyer? You sure? Do you want to apply for a court-appointed lawyer, ma'am? It's okay. Let me give you a lawyer, okay? Just don't get in any trouble. Okay, all right. Do you mind giving her a lawyer, please? Or an application? I need you to fill out an application for me. Fill it out. And then I'm gonna have you sign a receipt of Victoria. We'll have you take a seat in the jury box while we find your lawyer, ma'am, okay? Please.
Judge, this is DWI PTI intervention. Ms. Harvey's been removed from the program. Harvey, yes, Judge.
I'm bringing him up.
Ms. Harvey?
Good morning, Mr. Horn. It's been a while.
I didn't have.
I was hoping you'd give me some good news.
Here we are, Judge.
Shh. What did she pick up? Don't. Stephen, do you have room back there?
This is one of the fastest ways to lose a judge's trust. When someone picks up a new criminal charge while already out on bond, judges often see it as proof that previous warnings weren't taken seriously. Watch what happens next. The consequences can escalate very quickly.
I don't know what to tell you, ma'am. You picked up a new case while you're on bond. We have one thing that we do when people pick up new cases, right? I have to revoke her bond. Sorry, ma'am. She goes with you.
Judge, if we could talk about right now.
Sure.
Judge, we'd ask for a $500 bond. Judge, this is, she was on the program for, it looks like about 8 months. I don't know if there were any other violations. I just been on this case for 24 hours. But I know the new law violations triggering what we're triggering. But I believe she was in compliance on the DWI program. She was in compliance up to this new law violation. So,
Is that right?
oh, no.
Yeah, I mean, she was, but now they've, so I'll set the bond at 2501. Okay. But understand it's now time to decide what we need to do.
That's great.
If she wanted to do something today,
Judge, I'm just retained. Let me get her bond out. Yeah, Judge, may I have 6 weeks?
oh, 6 weeks is, the max I'll give you, it's 520 days old. I'll give you 30, but at that time, and if she gets out, she needs to come here immediately for bond conditions because I'm putting an ankle monitor on her as far as like, what does she have now?
That's part of the program, Judge.
Do we need to redo bond conditions? Had?
Has, she still has, Judge.
Has. Okay, she has to remain in compliance and you need to advise her that she got to remain in compliance with that. If that goes out, the bond is.
That's correct, Judge. I advise her upon initial consultation.
So here's the deal. She's going to auto-populate on Monday. Well, I bet she's going to bond out.
Yes, Judge.
So she'll be back here within the next 7 days. And then I guess we'll come back at that time, give you a little bit more time for you guys to decide what you want to do. But after that, it's plea or trial. Okay, Mr. Horn.
Thanks, Judge.
Thanks.
To let you know, I didn't tell you earlier, there was a time.
Give me good news.
Joshua Jones.
Oh,
So he's here for a PTI violation. He has picked up new cases.
come up, Joshua Jones.
I was just gonna ask you if we could withdraw. He's nearly a year past due. He owes us over $2,000. We don't want to get on the new case. Allow him some time to hire an attorney that can handle.
I'm okay with it. Yeah. Yes, that's fine. And so I will have to appoint him someone, Mr. Jones, let me express my disappointment with you. You were was he in the PTI program?
To my knowledge, he had a
You
previous
were in the
attorney.
intervention program for DWI, and now you've picked up another DWI. You now face another 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney appointed if you cannot afford one.
Yes, Judge. On November 17th, 2024, an officer was dispatched to a person down call at the 15,000 block Intercontinental Road. And upon contact, the officer made contact with a witness who advised he observed the defendant to be asleep in the driver's seat of his motor vehicle. Despite the witness's attempts to wake the defendant did not wake up.
Now we're entering territory that clearly frustrates the court. More than 3 years have passed. Multiple delays have piled up, and the judge wants answers. Court systems can tolerate some delays, but eventually patience runs out. And when it does, judges tend to make that very obvious.
And the witness turned the defendant's vehicle off in order to maintain his safety. The officer observed the defendant asleep in the driver's seat of the motor vehicle and also had unsuccessful attempts at waking up the defendant. When the defendant finally woke up after the officer made physical contact with him, the officer observed an unholstered black pistol in the driver's door and 2 half-consumed alcoholic beverages inside the truck.
Drinking while driving?
Yes, Judge. And standard field sobriety tests were refused. DIC was read and the defendant consented to breath and blood. Blood was drawn due to the defendant being unable to give 2 breath samples.
Mr. Jones, I'm going to find that there's probable cause to go forward with the case. I am now finding that you're a complete and utter danger to the public, and I am taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive, and I don't give a rat's behind what your excuse is if I find that you drive. I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand? Because of the nature of the case, because you have an open container, 2 open containers with the DWI, I am now revoking both of your bonds and I'm going to set them at $25,000 each. Do you understand? He goes with you. I'll sign your motion to withdraw.
4 years of missed court dates end here as the judge orders an ankle monitor.
You, Zader Yanez.
Sir.
Mr. Yanez, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Yes, Judge. On November 14th, 2024, officers were dispatched to a theft at a Home Depot in Harris County, Texas. The officers made contact with the complainant. The complainant observed the defendants enter the store, they observed the defendant walk into the store, walk to a hardware department, and approach a high-dollar Milwaukee hammer drill. The defendant, Yanez, selected 1 drill off the shelf and proceeded walking around the hardware department. The defendant handed the drill to the co-defendant and both proceeded to the plumbing section. The defendant opened the drill box, removed the drill from the box, and helped conceal the drill into the co-defendant's purse. The defendant discarded the empty box and both proceeded towards the front of the store. Both defendants passed all points of sale without paying. The total was $199.
Okay. Mr. Yanez, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to go to any Home Depot whatsoever. Do you understand? If I find that you go, I will revoke your bond, put you in jail. You will not get any more PR bonds. How old are you, sir? How old are you?
25.
What do you do for a living?
Distribution clerk.
Did you graduate from high school?
Yes.
What kind of money you make?
What kind of money I'm making? 17 an hour.
We're going to reset your case to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. After that, I'll have you take your seat in the jury box. We'll get your bond conditions. We'll have you sign it. You're also not to have any contact with the co-defendant in this case. Do you understand? You violate any of these conditions, you pick up a new case, I'm going to keep you with me, and it's not going to go well for you. You understand? Okay. All right, come on.
Page 1, Adams.
How many bonds have we given or reinstated for Mr. Adams here?
So 3 in total, 1 GOP, 1 reinstatement, and then
And now he gets another PR bond?
this one was issued on this last one.
Do you have a lawyer today, Mr. Adams?
No, sir.
Your case is 1,258 days old. It is time to put.
Think about this situation for a second. The officer finds a driver unconscious, open alcohol containers nearby, and a handgun within reach. Even before any test results come back, those facts alone are setting off every alarm bell in the courtroom. Cases like this are exactly why judges sometimes prioritize public safety over giving someone another chance.
This baby to bed. Take a seat for me. Okay,
It's
it's a really old case.
yes,
I've told him it's time to put this baby to bed.
yes.
Is there an offer in this case?
Your Honor.
No,
How come after 1,258 days, there is no offer?
I'm hoping we can get a gun safety class and dismiss.
It appears that was.
Come on, Mr. Adams.
The delay is probably due to the missing dash cam that's still outstanding that we do not have.
I don't care.
Yes, Judge.
Get on it now.
Yes, Judge. Well,
Why on earth would we allow you to do this class where you get to dismiss this case when it's 1,258 days and you've repeatedly taken off? It's a rhetorical question. You don't have to answer it. But I'm telling you now, I'm giving you 2 weeks to decide what to do with this case. The next time you come here, you will either accept a plea bargain agreement or I'm setting your case for trial. Do you understand? Not only that, I'm putting an ankle monitor on your ankle now so I know where you are at all times. Do you understand, Mr. Adams? And the next time you take off, I'm going to make your bond so high you're going to have teeth falling out. Do you understand?
Judge, if I may, my client, shortly after this arrest, he lost his mother, and I believe it's the mother of one of his children.
No, my sister.
Sister. He fell on hard times. He was already, not well employed. And he's been through some rough times in his life in the past few years. He recently got a job working at a Chinese restaurant, and he has 3 children that he helps take care of. I'm not exactly sure when his last failure to appear was. It might have only been 1, but he hasn't been in trouble since this arrest, I think in 2021, right? So I asked the court to withhold from, giving him an ankle monitor. The state's also missing.
This moment isn't really about punishment, it's about accountability. The judge has reached a point where promises aren't enough anymore. An ankle monitor sends a message. If the court can't rely on your word, it'll rely on technology. Do you think the judge is being too harsh here? Or is this exactly what a 4-year-old case deserves?
Last time
Let
we
me
saw
know
him
in the
was
comments.
3 years ago, Corey. So, I have sympathy in the fact that everybody has hard times, but your failure to appear on a repeated basis is a constant kick in the ding-ding to us, and I'm not going to take it. And I'm going to tell you now, I don't know why your bond is not at 10,003, because that is what it really should be. Your bond is at 1,002, and it's way off of what it normally would be. Because I'm telling you, your bond should be 10,003 because that's what they're normally set with a person who has absconded as many times as you do now. You're lucky that you're not in custody as it is now. Do you understand? But at 1,258 days, I don't trust you. And so the only way I know that I'm going to keep tabs on you is with an ankle monitor. And like I said, the next time you take off, and it doesn't matter what the excuse is, the bond is going to go astronomical. Do you understand, Corey? I'm sorry, but if it were maybe 500, maybe 300, I would relent on not putting a monitor. But at 4 years or however long this case is, hell no.
I think that reflects his law-abidingness, right? That he hasn't been in trouble, had any interactions with the police.
How do I know that?
Well, yes.
I don't know.
He hasn't been. He would have been in an orange jumpsuit, I guess, if he
Not
had to.
necessarily. I mean, we don't know how he's been out of county, out of state. Look, you're walking out of here now. You're getting 2 weeks to decide what to do. You're not going into custody now. So you're still walking out of here, but I'm putting a monitor on you. And I'm telling you something else that I should make you pay for it, where it would cost you around $400 to $500 a month, but I'm going to eat it. So there's no excuse. Do you understand, Ms. Adams? But you got to understand that in court, we hold people accountable. You may be able to live your life like this outside of the free world, but not in court. We will hold you accountable. And the next time, get ready. Take a seat. Thank you.